All right, y'all. Hello, everyone. It's your girl, Kamisha Tyler, aka Sarathea I Am, and on this feed, listen up. This is to those who wants to bring down the building. They want to bring down the whole entire building of my culture or my family, the way that I was raised within my family, my teachings, and they want to have an issue with that and want me to take the fall for how I've been raised and things that I've been put through in my lifetime. So, you guys know this case we're dealing with, CPS, and coming to find out, the petitioner here doesn't want to take into consideration any of the answers that I'm giving to her. Their main focus or their main goal is to discredit what I say. So I'm going to read to y'all something that's been typed up. So it's just called, it's pretty lengthy, so bear with me. It's called Defendant Special Appearance, an Omnibus Motion to Dismiss for lack of personal jurisdiction, lack of subject matter jurisdiction, and prosecutorial misconduct. So it says, comes now defendant appearing specially and solely for the purpose of challenging the authority and jurisdiction of this court and alleging severe prosecutorial misconduct, and without submitting to the general jurisdiction of this court, respectfully moves this honorable court to dismiss the charges and action with prejudice pursuant to applicable rules of procedure and constitutional protections. In support thereof, defendant states as follows. Special appearance statement. Defendant enters this special appearance pursuant to applicable state and federal procedural rules. Defendant explicitly denies that this court possesses personal jurisdiction over defendant or subject matter jurisdiction over the underlying matter. Nothing in this motion or any concurrent filing shall be construed as general appearance, a waiver of jurisdictional defenses, or a consent to the jurisdiction or venue of this court. Okay, Section 2, Statement of Facts and Procedural History. It says the petition filed by Lorena McFate is nothing short of hearsay. In Section 1 of the petition placed on the court desk at my challenge of personal and subject matter jurisdiction addresses the belief that the said child's physical, mental, and or emotional condition is substantially threatened or impaired, furthering into speculative insertion and the use of what I, Kamisha Tyler, have described as information provided and used as can be used against me. So in short, DARVO. This is abuse onto the mom. In Section 4, the speculative allegation against me, Kamisha Tyler, to make claims of and for CINC, child in need of care, I have challenged in juvenile court personal and subject matter jurisdiction against allegations against me of abuse, neglect, and dependency. Into Section 5, the agency takes presumptive action concerning my behavioral symptoms as stated in Section 4 and mentioned elsewhere. Starting around April 19th, it says referrals, which are the anonymous calls made, true or not, provided the act of Horton to abduct my child, Nathaniel Palms, from inpatient behavioral health, with stating concern of abuse, neglect, and or dependent child in need of care. Horton has stated that her investigative finding is abandonment. See the attached. In Section 8 of the petition, the agency stated that my child fears me. The diagnosis, medical discharge, stated that he has anxiety as a determining factor to Nathaniel's behavior and emotional withdrawal. Again, at having provided previous information seeking assistance for my child and family dynamics, what I, the biological mom, have informed as concern was used as DARVO against me throughout the petition by McFate. So basically everything that I said was going on and we were seeking help for, they turned it around and said these are the things of or from their investigation of abuse. So throughout the petition by McFate, the second sentence in Section 8 lacks relevance. amidst an abandonment finding for Nathaniel on the 24th of April 2026, as well as the first sentence of Section 9. The second sentence of Section 9 is dishonesty, as Ms. Horton had closed out Nathaniel's schooling registration without my consent and under duress of withholding my child's whereabouts, have acted solely on her own behalf. Sentence 3 of Section 9 is speculative and presumptive use of the compilative harassment from the agency, CPS, and corporation, and has fed the constant appearance of CPS workers on referral made use of relevance of past allegations in this matter that have been investigated and closed. Okay? Section 10 concludes their investigative findings. All at never having contacted me to discuss or inform me of the illegal act to abduct and request custody of a child on the basis of speculative concern, outside of personal matter jurisdiction, and the presumptive behavioral symptoms from compilative inserts of investigated and closed cases to build preponderance. Their conclusion is thus that Nathaniel and I need care under your organization for a child in need of care, making claims that I am the one to be charged for the needing of that care while using Darville fact against my evidence filed in reasoning support of the evaluation and anxiety diagnosis. See the handwritten notes filed sharing the abuse done onto the family. As set forth, the initiating charging documents and notices of Darville from corporate entities of immunity demonstrate a pattern of deliberate prosecutorial overreach. Section 3. Legal memorandum and grounds for dismissal. Okay. Personal jurisdiction requires proper service of process, valid statutory authority, and constitutional minimum contacts adhering to the Due Process Clause for the 14th Amendment. Defendant is not subject to personal jurisdiction because service of summons process was defective, insufficient, or absent altogether under applicable procedural rules. To have stated, service of court process as due process is a legal use of case jumping between Horton's illegal removing of my child Nathaniel by court service process of gaining a court order on the illegal grounds stated above, and McFate and Zapplito stating that my due process rights were not violated at placing a petition on the desk in front of me as I raised personal and subject matter jurisdiction challenge against any further alienation acts from these corporate officials, seeking the time needed to claim legality at forceful family separation, coercion, and interference through forceful insertion, while requesting that I refrain from being argumentative with facing my child's abductor. 2. Defendant lacks minimum contact with this forum, state, district sufficient to confer jurisdiction. 3. Exercise of jurisdiction by this court would offend traditional notions of fair play and substantial justice under CPS immunity, whom practices entrapment sentencing within the court proceedings. Okay, next one, dismissed for lack of subject matter jurisdiction. Subject matter jurisdiction is a fundamental prerequisite that cannot be waived and may be raised at any time. A court lacking subject matter jurisdiction has no power to hear or determine a case. This court lacks subject matter jurisdiction over the alleged action due to failure of the prosecution to allege facts establishing essential elements required to confer statutory jurisdiction. Improper invocation of statutory or constitutional authority not applicable to the defendant or underlying acts. Preemptive or exclusive jurisdiction vested in another tribunal or forum. Motion to dismiss for prosecutorial misconduct. Prosecutorial misconduct that violates due process, interferes with constitutional rights, or degrades the integrity of the judicial process warrants dismissal of charges with prejudice. Specific acts of prosecutorial misconduct include, but are not limited to, Brady/Giglio violations, suppression or failure to disclose exculpatory or impeachment evidence material to the defense, vindictive or selective prosecution, bringing charges motivated by animus, retaliation, or improper selective enforcement rather than legitimate legal grounds, abuse of process, misuse of grand jury procedures, subpoenas, or judicial authority to harass defendant or obtain evidence unlawfully. How does one not give up their seated stance under these tactics? A petition set in front of me from CPS showing the reason for their justifying of illegal removal or requesting for foster care custody involvement, noting the due process of this as the sliding scale deception congruent to my personal and subject matter challenge, stating no due process was given, and asking for the factual findings of legal authorities supporting your ruling and action of Horton, disvalidation of answers, notices, etc., in order to cause litigation, disrupt, or abuse from the defending mother of her child, finding none of which nullify my parental rights, keeping absolute authority of my children or child. So prayer. It is a problem when the legal system uses measures to stalk individuals into submission for deny, attack, reverse victim and offender roles, as though transgender choosing, at their sharing of diagnosed limitations. A setting aside of the fault emotion to try the health factor of households at communicating and showing efforts to resolve matters. In good faith and honesty of income or poverty matters, press discriminately in antithesis amidst the wealthy and strangely odd behavior within low-income families having a valid defense, yet intimidated to remain in silence through threat, duress, and coercion herein stated. I object to all presumption, allegations brought against me by use of Darvo, instructed to plead the fifth at not knowing how to proceed within a game of law when my rights, my body, autonomy, freedom of speech at telling the truth, whole truth, have been up to this point violated and compromised by the very systems of legality and justice seeking to implement their justice card over my life and well-being. Respectfully submitted. I hereby certify that a true and correct copy of the foregoing will be administered.